McCarthy.
Thank you, Minister, for being here. I welcome the opportunity to contribute to this important debate. At the heart of the legislation is a simple question: how do we protect the right to a fair trial while also protecting those who have already experienced trauma? And I think the examples that are given, even visitors in the gallery, Paulus, our own story was given. I believe the legislation must, and I believe it can do both. But I know counselling is one of the few places where survivors of abuse, sexual violence and domestic violence, that's where they get the opportunity to speak freely. And it's where they begin to process fear, shame and trauma. And they do so believing that what they're saying is confidential, except in the most exceptional circumstances, which you know are provided for by the law. But Minister, if people begin to fear that their counselling notes could routinely become part of a criminal trial, many then will simply stop talking. You know that I'm involved in Tiglin, and we have Women's Refuge, and I know that some of the women have told me if this became the case, they would actually avoid counselling altogether. It would involve censoring themselves, and I think that would be a huge tragedy for themselves, not just for themselves, for healing from the trauma, but also for society. You know, I've spent 20 years before entering politics working with men and women who have come from a traumatised background. And since this legislation came to public attention, I've been contacted by many, many women asking, does it automatically mean that my counselling notes will be disclosed? If you were in my shoes, should I stop going to counselling? And is what I tell my counsellor really private? So the fact that survivors are asking those questions, I think that should really concern us all in this House. Counselling notes, you know, they're not statements prepared for court. It's where somebody feels vulnerable enough to share what has happened to them. And often the case, people, when they're vulnerable, they start questioning themselves and saying, did I lead that person on, etc., which would not be the case, but you start to question in a very protected place with your counsellor. And so these should not be police reports or forensic reports. They're often a record of somebody's healing journey, where memories are explored, emotions are expressed, and then the trauma is processed. So they're written strictly for therapeutic processes and not evidential ones. So of course, Minister, the rights of an accused person, they're fundamental, and every person must be entitled to a fair trial, and nothing what I'm saying here should diminish that. But victims, such as Paula, who's been mentioned here, they have the rights, and they need the right to dignity, to privacy, and to recover from that trauma without fearing that the most intimate conversations that they've had with a professional counsellor may later be examined in open court, unless there's a compelling and clearly justified reason for doing so. So that's why the threshold, I believe, for disclosure must be exceptionally high. An application should be based on genuine necessity and relevance, not speculation or used as fishing expeditions. Judges should continue to act as careful gatekeepers, weighing the justice, of course, against the real risk of causing further harm to the victims, as my Senator colleague Stevenson has said. Over many years, we've encouraged survivors to come forward, and that has really progressed over recent years, to report abuse, to seek counselling. So we shouldn't undermine all of that progress. Even if we even have a small number of victims deciding not to help themselves because they fear the counselling records may be later exposed, I think then we fail, and we fail badly. So this legislation is more about, is much more than about legal procedure. It's about trust. And it's about trust in the justice system. And that trust that when somebody takes the brave step to ask for help, we protect their rights, but we also protect their dignity. So I hope, Minister, in this House we can continue to both uphold the constitutional right to a fair trial, but also the equally important principle that counselling must remain a place of safety, of healing and of hope. Thank you, Minister. Thank you, Éireann.